Welcome to this presentation covering Chapter 9 of our textbook. The name of this chapter in the textbook is Your Responsibilities as a Hospitality Operator. And I suppose this title isn't awful, but it's probably not the best title. Really what this chapter is about tort law. And so that's what I'm going to be calling it. So when I, in the future, refer to the tort chapter, I mean Chapter 9. I was a little surprised to see that this topic got only one chapter in the textbook. Actually, you could argue that there's more than one chapter. You could say that there's two chapters, but it's a pretty important topic, and it probably deserves a bit more coverage. But in any event, we have one chapter to go through, and I'm going to try to cover a little bit more than perhaps the textbook author has given you. If this topic interests you, we have a whole course on this topic in the paralegal program, and it is LGLA 2303. This is the course that covers torts and personal injury law. As you can see by having a whole course on the topic of this chapter, there is a lot more that we can say about this. In law school, for most students, most future lawyers, it's a year-long course called torts. And so we're just going to kind of graze some important ideas here, but there's a lot more to be said, and so if this topic interests you, I hope that you'll consider perhaps enrolling in this course as well. So let's get an overview of what your responsibilities are with respect to tort law when you're a hospitality operator. And when I use that term, I'm referring to somebody who operates a hospitality business. It could be a restaurant, a bar, it could be a hotel, it could be an amusement park or a theater or some other venue along those lines. Convention center, for example. So we're going to, in this particular chapter, talk about, number one, what are your duties and obligations as that hospitality operator. We're also going to talk about when a problem arises, what types of legal theories are in play that may influence whether you're going to be ultimately held responsible. When I say you, I mean the business, ultimately held responsible for whatever happened, or are you going to be able to escape liability? Then we'll talk so briefly about the topic of how damages are calculated. We'll go through the typical steps in a personal injury lawsuit, and again, personal injury in this context means a tort lawsuit. And then we'll talk about how you would handle, or how you ought to handle, an issue that comes up in real time when there's been an accident of some type. In some sense, this is out of order because this is the first thing that happens, right? An accident happens and you respond to it, and probably your response, at least the first stages of the response, are things that either happen or don't happen in the first 30 minutes of the incident, long before you're even thinking about a lawsuit or damages or appeals or any of that kind of stuff. So in terms of chronological order, this is going to be the first point that's going to arise. But in order to make sense of this, it's helpful to have some context and understand kind of why these steps are necessary. Well, to get that, you have to have a deeper understanding about the theory and the structure of tort law. So we'll kind of do these a little bit out of order, but hopefully it'll help make more sense out of why we're doing what we're doing. So in this chapter, we're going to talk about the different types of duties that a hospitality operator has toward his or her guests, and in some cases employees, and what will happen when a hospitality operator, or more likely its employees, do not satisfy those duties. We'll talk about how do these duties affect how a business in this particular industry ought to operate. What changes or what concerns should that operator have when he or she is designing the policies and procedures. We'll talk about how a lawsuit proceeds through the court system, and also connected to that is we'll talk about alternative dispute resolution and what that process looks like. And finally, we'll talk about a plan that you might consider. It could be very broad brush. You'd want to get more specific for your particular business. But some steps you would want to consider to have in place when an accident happens. And again, I use the word when because there will be an accident. Someone will get hurt, somebody will fall, there will be an assault. Eventually, one of those things will happen. And one of the big tests is, how do you respond to that when it arises? Can we stop it from happening? Well, certainly we can do things that reduce the likelihood of it happening, but there's no magic pill that we can take that will protect us from this ever happening. And so we need to have a plan in effect. We need to make sure that we update the plan to reflect changes in our business, changes in the risks that our guests and employees are exposed to, changes in technology. Then we need to make sure that our employees are very familiar with the plan. This probably is going to involve some drilling, some practicing of it, maybe even some dry runs, kind of like fire drills, so to speak. And certainly it would be part of any kind of new employee orientation. It ought to be regularly raised in staff meetings and maybe at the annual appraisal time, so that everybody knows what to do and also what not to do. What are the mistakes that can be made in this context? And of course, if you have this plan well thought out and it's ready to be well executed, many of these risks that we have up above are going to be diminished. So let's get started. Let's talk about these duties. Well, let's first of all stop and think about what are the elements of a tort. The first thing that we need to have in order to have a tort, and of course we don't want a tort, but let's just look at what the building blocks are of a tort. What are the elements of a tort? And again, when we see the word elements, we should think ingredients. Kind of like if you're making wool, like a Viennese tort, a chocolate cake from Vienna, the dessert tort. If you were making that, you would need certain ingredients. You would need some chocolate, you would need some flour, you would need some sugar, you would need some type of fat, probably some egg. There would be certain ingredients that you just have to have or you're not going to have a Viennese tort at the end. Well, the same idea exists in the law. There are certain things you have to have. If you're missing one of the elements or one of the ingredients to a tort, you're not going to end up having a tort. Now, some ingredients are optional, but the ones that are required, if you don't have those, you're not going to have a tort. You may have something else, and it may even be legally relevant what that item is, but it's not going to have the name tort. So let's look through the 4 elements that we have to have for tort. The first element we talk about right up here. We talk about a duty of care. This is a legal obligation to protect someone, in this case the plaintiff. I'm just going to put the plaintiff here, which of course is the pi sign. The plaintiff from harm. And again, this is that first element of tort. The first thing that we think about, this would be the equivalent of if you're making a baked good, first thing you might do is preheat the oven, or you might butter and put flour in the pie pan or something along those lines. One of those very first steps that you do kind of even before you start making or baking. Okay, so we're talking here about what our obligations are before anything has gone wrong to this plaintiff. Now, sometimes in life when we're talking about torts, we have a relationship. We, the defendant, that's the role, of course, we would take in this type of lawsuit. We, the defendant, have this duty of care towards the plaintiff. Sometimes the plaintiff may be a complete unknown to us. For example, let's say that our hotel runs a shuttle to and from the airport. And our shuttle driver is in an accident and he hits another car and people in that car are injured. Well, in that case, the shuttle driver has breached a duty of care. His responsibility is to drive safely, and he owes that duty of care to everyone else who is on the roads. But of course, the driver of the shuttle did not know the person that he hit with his car. He didn't want to hit that person with the car. He's upset that he hit the person with the car. This is not good news to him. He didn't have any kind of relationship before, and he probably isn't really going to have one after. So when we talk about a duty of care, it's not really individualized that Bob owes Sally a duty. It's that Bob, the van driver, owes anyone in those circumstances a duty, and Sally happened to be just the unlucky person who was at the wrong place at the wrong time. Many times, though, in the hospitality industry, we do have a more specific, a more defined relationship with our plaintiff, because the plaintiff may be a guest in our hotel or a guest in our restaurant or bar. So many times we do have an already existing relationship with him or her. And so in that sense, we can easily kind of imagine what our duty of care would be. If Louise is a patron of our restaurant, we have a duty to protect her from having an incident in the building where she falls. If there's an unsafe thing that's in the restaurant, or maybe we have a duty to make sure that the food that she eats is wholesome, isn't spoiled. We might have a duty to make sure that the parking lot is safe and well lit. Things along those lines would be duties that we would probably already know that we would owe to Louise. We already have a relationship with her. She is our guest. So sometimes we know the person, sometimes we don't. But whether we have a relationship with that person or not, we still owe that person a duty of care. So that's the first element of tort law, this duty of care. If we don't have a duty of care towards someone, then guess what? We can go home. We don't need to, we're not going to have any kind of legal obligation toward that person. So let's look at some duties of care that exist in the hospitality industry. We have to provide a reasonably safe premise. Now, this doesn't mean that no accident would ever occur. If you have a staircase or any kind of steps, it's always possible that someone will trip and fall. And so under those circumstances, it doesn't follow that just because somebody tripped and fell, that the place where they tripped and fell is necessarily liable. They could be liable, that's certainly a possibility, but they may not be liable. The owner of the premises is not an automatic insurer, no matter of whatever might go wrong in the place. But the duty is to provide a reasonably safe premise. And we'll talk more about the word reasonably as we go further into this chapter. Of course, we also have the duty to serve food and beverages that are fit for consumption. They're not spoiled. They reflect they're cooked at the right temperature so that the food is not likely to make someone sick. If a person has indicated that they have an allergy to a particular substance and we agree to prepare them food, given that information, we actually do follow through and provide food meeting those consumption requirements. Now, of course, this isn't a statement that the food is going to be tasty or that the drinks are going to be delicious. We're just talking about it's not going to make someone sick. Another thing we have a responsibility is, and this is both to the patron and also to the larger society, is to serve alcohol responsibly. Obviously, part of that is making sure that we are not serving minors, but even people who are over the age of 21, if we overserve them to the point that they are they're not sober, and then they go out, drive a car, and they're in an accident, we've seen under the dram shop statutes that the server can be responsible to the victim of that accident. Even though that victim of the accident wasn't ever our guest, they are people whom we owed a duty of care to, because it's foreseeable that one of our patrons, if we overserved them, could be involved in an accident. It could cause harm to the other person. We also have the duty to hire qualified employees. Now, in many of our areas, that may not be kind of obvious or how that's going to impact. For example, if a waitress or waiter is unqualified, it's not likely that they're going to make somebody sick. But we could see situations where you have a chef who is unqualified and he or she doesn't know to cook the eggs or the meat to a certain temperature that is safe. And so they serve food that is undercooked and that causes an illness. Or maybe somebody who is running the kitchen cleanup process who doesn't do a good job, and dishes that were not clean are actually reused, and that contamination makes people sick. So qualified can mean different things in different situations. We're probably talking primarily about food safety here. But we could hire people, maybe an electrician, to rewire something in our facility, and if that person really wasn't qualified to perform that electrical work, and after they're done with the work and we have a full house, there's a fire and people are injured, well, we could be responsible because we hired unqualified people to do those particular tasks. We also have a duty to properly train employees, make sure that they know what to do. So let's say there is a fire. Well, were our employees trained about how to safely and quickly facilitate the exit from the facility of all of the employees and guests? That would be something one would want to address. Have we trained the employees about how to prepare our particular dishes? Maybe the employee knows how to prepare a dish so it's safe, but if we don't provide them with the right equipment and the right skills for our particular kitchen situation, they may not be able to apply that knowledge they have in a different circumstance. We also have the duty, this is going to sound strange, but we also have the duty to fire people. People who aren't doing a good job and who might pose a danger to others, they need to go. So if we have an employee who is grabbing people in the halls and assaulting them, or who is coming to work drunk and is perhaps not cooking the food appropriately, or who becomes belligerent with either coworkers or guests and might pose a danger to the other people with whom they work and also the customers, that person needs to go away, because the continued employment of that person puts the enterprise at risk for lawsuits from either other employees or from guests. Now, of course, whenever you fire someone, there's always a risk that the person you fire may file a lawsuit. So you have to consider how this particular person's employment status affects your overall legal risk. But so you want to consider it both from the perspective of the employee you're terminating, but also from the perspective of individuals that may be affected by this person's continued employment. We also have the duty to warn of unsafe conditions. Ideally, we don't want to have unsafe conditions. We want our facilities to be very safe, but there can be times, maybe it's raining outside, so a puddle is formed. Maybe there's a leak. We're trying to fix it. The roof is leaking here, but we can't magically fix something immediately. Perhaps we are in an historical facility, and so some of the aspects of the facility might not be kind of perfect. For example, maybe the staircase is narrow or especially steep. Maybe it's not completely level. And so there are times where either we can't solve the problem at all, or we can't solve the problem right now. And under those circumstances, we absolutely do have an obligation to warn our guests about the unsafe condition. If we warn them, and if they do not heed our warning, then they may find it more difficult to successfully sue us. And then if we keep our guest property, let's say we have a safe in the hotel and the guest drops off some items into that safe, maybe jewelry or personal effects of some type, we have the obligation to keep that safe, and both from theft as well as from fire and other possible losses, and then return it to the guest in the condition in which it was given to us. So those are some examples of duties of care that we in the hospitality industry would owe our customers and our guests. It's not a complete list. Certainly depending upon the particular business, there could be other concerns here, other things that we might have in mind that could affect what these lists might be, but these are some good starting ideas to have. Okay, so we talked about the duty of care. A related concept is the standard of care. So let's flip to the next slide and look at this. This is the industry recognized, reasonably accepted level of care used in fulfilling a duty of care. So when we know this, we know what we have to do. This is our duty to satisfy. And you can see that we have this word reasonable, and we'll see this word reasonable lots and lots of times. If a hotel or hospitality operator fails to meet the standard of care, it means that he has breached the duty of care. So a breach of the standard of care is breaching that duty of care, which is, of course, our second element here. We find that most tort claims are going to be related to this type of negligence theory that we're talking about here. I call this elements of a tort, but this is really specifically elements of a negligence tort. Should have included that there, I apologize. This is a particular subgroup of torts, and this is by far the most common type of tort that we see in the hospitality industry. We'll talk about two other categories briefly, but this is by far the most important. Okay, so now we've seen this word reasonable. I think we've seen it 3 or 4 times, and we're only on slide 7. So this is a really, really important concept. I mean, it's an important concept throughout the law, but it probably, no area of the law is it more important, and this may be the one where it's most important, is in the area of tort law. When we use the word reasonable in tort law and elsewhere in the law, we're using it in a very specific way that may not be obvious to the casual listener. And that is what we're doing, is we're talking about an objective standard. You know, the fact is each of us think that we are reasonable. It's like we all think we have common sense, and yet we all know people who don't have common sense. And yet if you think about that person who doesn't have common sense, you're probably going to think, well, you know what, that person probably thinks he has common sense. And similarly, we all think that we ourselves are reasonable. But after all, if we all think we're reasonable, we all can't be reasonable. So this is not something we can diagnose within ourselves. I'll give you an example. I think of myself as a pretty reasonable person. And my guess is if you and I got to know each other better, you'd probably think, yeah, I mean, Groover's got her quirks, but yeah, she's pretty reasonable. But there is one area in my life that I fully recognize I have a quirk. I'm going to share it with you just so you can have a point of reference, what I'm talking about when I talk about reasonable people. Since, well, my entire life, since before I can have memories, I have just really, really strongly disliked French fries. It has always been an aspect of who I am. The smell of French fries makes me pretty darn close to physically ill. I don't like to sit at a table with somebody eating French fries because of that smell. Now, I'm not some health food nut. I love potato chips. I love mashed potatoes. I love baked potatoes. I like hash browns. But French fries are just about one of the most disturbing foods that I can be around. And I'm not picky about foods generally, but just that food and that, particularly that smell, just makes me really uncomfortable, and I really, really, really don't like that smell. It smells like spoiled food to me is what it smells like. I'll be honest with you. Garbage that you just don't want to be around. But you know what? I recognize that my experience of French fries is unusual, and that the vast majority of people, probably every person in our class this semester, is thinking to themselves now, that is very strange. Groover has a very odd and quirky reaction to French fries. That is not a reasonable person reaction, because most of us think French fries are delightful and tasty and they smell good. And most of us think to ourselves we shouldn't eat them because they're not especially good for us, but they certainly are tasty. And so once you hear this about me, you're probably thinking, you know what, if Groover were to say to me, well, I don't really like that restaurant over there, I might not take her review that seriously because she's got a weird palate, right? Okay. And so in your mind, probably to some degree, I've lost my reasonable person card because you know about this quirk about me. But you know, the reality is we all have quirks. Yours may not have anything to do with French fries or even with food generally, but you've got something about you that if you were to be honest, you would have to admit, you know what? Those people just don't feel that way. And I might really be right, and the rest of the world may really be wrong. But the average person, if they knew this about me, they would think, that is a little bit odd, and that is not a reasonable person. So we all have our little things out there, different things for each person. That's not what the law cares about. The law doesn't look at the quirks of an individual person. Instead, the law kind of takes an average of all of humanity, or at least all of people in Collin County, for example, if a case were filed in Collin County, and kind of comes to a general judgment about what's a reasonable person in Collin County. He or she is a person who has average intellect, no rocket scientist, but no dullard either. Somebody who has average life experience, probably somebody who hasn't lived every single second of his life in Collin County, but also probably someone that hasn't lived on 5 different continents either. Somebody who has some education, probably at least some college maybe, but probably not a PhD in astrophysics or something like that. It's kind of your average individual. But we're stripping away any of those quirks because we recognize each person has his or her quirks. We're not interested in those things that makes that person unique or unusual. We're interested in what makes that person typical. It's an objective standard because we're not looking at all those subjective, quirky things that each individual has. We're looking at a reasonable person. So when we go back to the tort situations, let's say, and this happened to me once, I was having an especially frustrating day. I went with my family to, I think it was a Long John Silver's. And whenever we go to Long John Silver's, I always say, please don't give us any French fries, just give us extra hush puppies. And I got the food, and I had at this point in time 2 little kids, and I brought home the food, and I had put it was in a big kind of plastic container, and I hadn't been able to smell it till I got home, and I see that they didn't give me the extra hush puppies. They had given me all these fries. And on the way home, the fry smell had intermingled with all of that fried fish and the hush puppies they had given me. And so none of it was really edible for me. And so I threw it all away. But you know what? A reasonable person would not get that grossed out by the smell of French fries. So my reaction wasn't reasonable. Now, when I say it wasn't reasonable, I don't mean to say I was crazy or that there was some very strange thing going on in my head. What I'm saying is that my response wasn't typical. The average person who maybe prefers hush puppies over French fries and who gets French fries says, well, gosh, I wish I'd gotten the hush puppies, but they're not, the end of the world or anything along those lines. And so it's a disappointment perhaps, but not something that's catastrophic. That's what the average person would respond. For me, it was a deal breaker. But I'm quirky in this area. And so we don't look at an individual's quirks. And the one exception can be sometimes when you communicate clearly, hey, you know what, I'm allergic to French fries, or I'm allergic to whatever it is, so I really can't have any of that. Then that's in a different situation. So whenever we talk about reasonable person, we're talking about that average person, that objective standard that is not looking at the quirks or particular idiosyncrasies of a particular person. So let's look at the actual definition of tort. A tort is an act or failure to act, not involving a breach of contract that results in injury, loss, or damage to another. This definition is pretty close to the one in the textbook, but I did do a little bit of wordsmithing on this because it wasn't flowing exactly what I thought was the best way. One thing I will say about the definition of torts, whichever one you happen to use, is that torts are, it's a little bit, I think we talked about this when we were talking about contract law. It's a little bit like the term contract. It's such a basic concept to the law that you really can't define it. If we were to look up, let's just do this for a second, just to kind of play around with this. If we were to look up the word the, definition of the, denoting one or more people or things already mentioned or assumed to be common knowledge, used to point forward to a following qualifying or defining clause or phrase. You know what? If you don't know what the word "the" means, having read this, you aren't going to have any clearer notion. In fact, my guess is that the average 3-year-old child knows what the word "the" is. Maybe they can't define it, but they understand how it's being used if they are, from an English-speaking country. But the average 3-year-old would have no idea what these two definitions are. So a definition of a word that's this simple really doesn't explain the term or help the reader understand the term. The definition is more complex than the word. Let's just do another one. Let's just look at the word red. We all know what the word red means. Red. Of a color at the end of the spectrum next to orange and opposite violet, as of red, blood, fire, or rubies. Again, if you didn't know what red looks like, this definition isn't really going to help you, because this is a more basic word in English than spectrum or violet or orange is. Little kids know what red is, but a little kid may well know not what a ruby is. So this is a more complex term, more complex definition than the term. Similarly, tort is such a basic concept in tort law, or in law generally, that you really just can't define it. All of these terms don't really necessarily add a lot of understanding. So we're going to use this term, and there's a couple of things I want to point to about this term, but we're also going to recognize that it's difficult to really have a definition for such a basic concept. One thing that's important to keep in mind about tort law is that it relates to both acts and what we call omissions. Omissions, those are failures to act. So it's not necessarily when I do something wrong, it can be my decision or my forgetting to do something. It doesn't have to even be a decision. I can accidentally forget to do something. For example, I might forget to repair that loose board on the steps. I didn't want anybody to fall. I didn't cause the step to become loose, just wear and tear caused that to happen. But I failed to fix that action as I should have. So it can be an act or a failure to act. Both of those can cause a tort. Then we also are exempting breach of contract. The thing about contract law is that when a person enters into a contract, he or she is choosing to associate with that other person. The other party to the contract is a voluntary association. For the most part, and there are some important exceptions, but for the most part, as a general rule, I can't be forced to enter into a contract with another person or another entity. So there's some voluntariness, there's some choice involved. Tort law, we really don't have that level of choice, though, because if I'm driving along the road, let's say I'm Bob the van driver who's picking up people at the airport, I didn't choose who was going to be in the car next to me as I'm driving down 75. It could have been anybody. And so if I change lanes and there's a car where I'm trying to change into and I hit that car, it's not like the driver of that car chose to be hit by me or chose to be driving next to me necessarily. That driver of the car didn't even know me at that particular time. And so there isn't the idea of association or voluntariness in tort law, or that you have some kind of pre-existing relationship as you would have with contract law. So we have an act or omission that doesn't require a contract that results in some type of injury to another person. Of course, this other person is going to be the plaintiff in the lawsuit. So we're talking about an act or omission by the defendant and the harm that is caused to the plaintiff. So typically show the pi sign for, and then this, of course, up here is the defendant's actions, the delta actions. There are 3 categories of torts. We have intentional torts, negligent torts, and strict liability torts. By far the most important is a negligent tort. That's the most important. Generally, it's also the most important in hospitality law. This is the car accident scenario. Again, Bob, the limo driver, he doesn't want to be in an accident with anybody. He's pretty upset about the accident, even if he's not injured. It's going to cause his insurance rates to go up. It may cause him to lose his job. He feels guilty because he's caused someone else injury. He may not be quite as upset as the person who's broken his leg, yes, but he's still pretty upset. It's pretty rare that car accidents are anything other than negligent. A person can intentionally enter the car in a road rage situation, but most of the time it's just an accident. Doesn't mean that the person who caused the accident was doing everything that he or she should have been doing, but they didn't have the intention of harming anybody. So that's where most of our accidents are, and this is how we see most of our tort claims arise in the hospitality industry. But there are also intentional actions. When I intend a certain action, and that action occurs and that action causes an injury, we call it an intentional tort. There's also strict liability torts. These are fairly rare in the hospitality industry, but they can also come up. These are situations where there's an inherently dangerous activity that is being engaged in, and as a result of the activity, somebody is injured. Well, the person who is facilitating that activity, that business, is sometimes held to be strictly liable for whatever the injury is that the participant actually had. So imagine, let's say you're a hotel business and you decide that you are going to rent a live tiger to be in the lobby of your hotel. You have him behind a plexiglass safe container, at least you think it's safe, but no, lo and behold, it breaks. The lion or tiger escapes and he eats a few of the patrons. Well, obviously their families are going to sue you. And even if you had a super safe container and you can show how you dotted every I and crossed every T to make sure that this container was as safe as humanly possible. So you weren't negligent in how you designed it. You certainly didn't intentionally want anybody to be hurt. But the idea is, hey, you know what? Whenever you involve wild animals like lions and tigers, there's always going to be a chance that something is going to go awry, and you know what? You're going to be held liable strictly, even if you're not negligent, even if you didn't act intentionally. That's the idea behind strict liability law. But again, the most important, what we're going to focus almost all of our energy on during this lecture is going to be the category called negligent torts. And again, it's unintentional. Bob didn't want to cause the car accident. What's an example of an intentional tort? Well, battery is. Battery is when you touch somebody. It can be a punch in the nose, which is obviously physically painful, or it can be a grope in the stairwell, which may not leave a bruise, may not physically harm someone, but is an unwelcome experience. That would be an example of an intentional tort. Now, I might grope you in the staircase thinking you're going to like it. I didn't realize it was unwelcome, but I'm still guilty of battery if I should have known under the circumstances it was unwelcome. The fact that I wasn't aware that I was injuring you doesn't excuse the fact that it is still an intentional tort. Here is the definition of negligence, and we see this word reasonable again. The failure to use reasonable care. Again, it can be an act or an omission, so it can be our decision to act in a certain way and that we failed to use reasonable care in doing that particular action, or it can be our decision not to take a particular action, and that can be a lack of reasonable care. Let's consider the doctrine respondeat superior. Respondeat superior we talked about in the context of employment law previously, and it's good to be reminded about this idea as we talk about tort law. You may recall when we were talking about employment law, the idea here is, or the Latin expression is, let the superior respond or be responsible for the action of the subordinate or the employee. And what this generally means is when the employee is acting within the course and scope of his or her job, whatever he or she does is going to either go to the benefit of the employer or to the detriment of the employer. Even if the employer didn't want the employee to take a particular action or do a particular thing, the employer is still, if the employee was on the clock working for the employer at the time, the employer is still going to be legally responsible for that. This also applies in the area of torts. Obviously, you as a hospitality operator don't want your employees to commit torts. You don't want your employee to not cook the eggs sufficiently well, or not to cook the fish to the right temperature or the chicken to the right temperature. You don't want that to happen. You've trained your staff, so you hope it won't happen. Maybe you've even fired some of your employees when they have presented undercooked food. But it happens yet again. You're upset. the patron has gotten sick, guess what? You're still on the hook. You are still responsible for the acts of negligence of your employees. So let's go back to our list of our elements for the net tort of negligence. We talked about let me just write the word negligence here again, because this is again focusing on the tort of negligence, not just any tort. So intentional and strict liability torts have different elements, which we aren't going to be talking about in this particular chapter. So we talked about the duty of care, we talked about the breach of the duty of care, and now we're ready to talk about causation. If you were taking a tort law course, we would talk about different types of causation, but we're just not going to get into that much detail here. We're just going to talk about the idea of causation, and we're going to use the term proximate causation, which is a legal term. So we think when we think about causation, we think about, well, A happens, and because A happened, then B happens. For example, if I see Bob's car stopped at a red light and I hit Bob's car, and then Bob's car is pushed into traffic and his car hits Sally's car, Sally's going the opposite way in the intersection, then I have caused that car accident. So I would be the proximate cause of that car accident. But you know what? There's a lot of things in life that we cause indirectly. Let me give you an example. Imagine that you are on vacation in Japan. You and I are acquaintances. I call you up. I'm here in Frisco, and you and I are on the phone as you are driving on a road in Japan, a busy road in Japan. While we're talking, I happen to I smell some cat dander in my car, and I have a very loud sneeze. It's startling how loud my sneeze is. You're driving along, you hear me make this big sneeze, and honestly, it causes you to swerve. You're not sure what was going on. What was that big sound that you heard? So you swerve your car because of the sneeze. Your car jumps the curb and it hits a hot dog vendor's cart along the side of the road in this Japanese town. The hot dog cart falls over, and a hot dog on the hot dog cart rolls down the hill. This hot dog cart was kind of at the top of a little hill. It rolls down the hill, and there is an elderly woman who is walking up the hill. Anyway, she slips on that hot dog, and she falls, and she breaks her leg. Now, you could say that I in Frisco with my sneeze caused that chain of events. If I hadn't sneezed, you wouldn't have been startled and you wouldn't have swerved the car. If you hadn't swerved the car, your car wouldn't have jumped the curve. If your car hadn't jumped the curve, it wouldn't have hit the hot dog vendor's cart. If it hadn't hit the hot dog vendor's cart, the hot dog vendor's cart wouldn't have fallen over. If the hot dog vendor's cart hadn't fallen over, that hot dog wouldn't have fallen out. If the hot dog hadn't fallen out, the elderly lady would not have tripped on the hot dog and broken her leg. So yes, I mean, my sneeze in Frisco did cause the accident. But we don't call that proximate causation. We actually call it but-for or direct causation or actual causation. But you don't need to know those terms for this course. But we do know it doesn't directly cause. There's too many steps. There's too many variables. It's really not foreseeable that all of those steps, while I'm sneezing in my car in Frisco, it wouldn't have been reasonable for anyone to think, you know what, Grover, if you sneeze in your car in Frisco, there's a pretty good chance that an elderly Japanese lady is going to slip on a hot dog, and that's all your fault. We would all say, well, I don't think that follows. I mean, I don't really see how that's likely to happen just because I sneeze in Frisco. Even knowing that I'm on the phone with somebody in Japan, it still doesn't seem really very likely. So you can be the indirect cause, but you're still not the proximate cause if there isn't a foreseeability between your actions and the end result. Many times there's more than one cause to an accident. Going back to the example that I had with the hot dog situation. maybe I shouldn't have been on the phone while I was driving the car in Frisco, or maybe I should have, turned my head so my sneeze would be kind of muffled. But you perhaps shouldn't be on your phone in Japan, and maybe you should have been paying better attention to the road so you wouldn't have been that startled when I sneezed. Perhaps the hot dog vendor was too close to the curb. He should have had his cart in a little bit more. Perhaps the cart should have been more sturdy and less likely to be tipped over. Perhaps the elderly Japanese lady should have been paying better attention to how she walked. You could see how perhaps all of those people bear some responsibility for the accident. So the fact that there is one proximate cause does not mean that there can't be many other proximate causes. Now, we've already said I'm not a proximate cause of the injury to the elderly Japanese lady, but some of those other ones perhaps are proximate causes. Certainly, if you become distracted while you're driving, it's certainly possible that you could cause a pedestrian to be injured. And so your action of swerving off of the road onto the sidewalk could be considered the proximate cause of the elderly lady's injuries, for example. Let's talk about the concept of gross negligence. Okay, this is the idea that somebody isn't just negligent, but they are extremely negligent. That they have kind of crossed the line and become very, very extreme. They've been reckless, not just careless, but reckless or willful. Again, we're not all the way into intentional levels, but they failed to even use the slightest amount of reasonable care. They're really, really, they're not in the gray area. They're not like, well, it probably wasn't reasonable, but not clearly unreasonable. No, they are completely in the black. No one would think that was reasonable. Give an example, going back to my story where I rear-ended Bob's car. I wasn't being as careful as I should have been. I was on the phone and I just wasn't paying attention and I hit Bob's car. I was negligent in the situation. An example of gross negligence would be if I decided to put a blindfold on while I was driving my car. That would be grossly negligent. Someone might say, well, Grover, it's probably best that you don't use your phone when you're driving, especially if you're going to find yourself that distracted that you would hit another car. But still, you can imagine feeling like, well, many people can safely drive and speak on the phone, so I wouldn't say that's grossly negligent. But certainly wearing a blindfold when you drive, I think we would all agree, yes, that is grossly negligent. So what is the significance of whether a person is just negligent or grossly negligent? Well, it's pretty huge. If a person is grossly negligent, then, and of course, this all turns on what the jury finds, if there's gross negligence, then it's possible that punitive damages can be one of the abilities or one of the things that the plaintiff can get. So this can make a huge difference in the value of a case for settlement discussions if the possibility of punitive damages exists. Usually in a negligence case, the court will not allow the jury to award punitive damages. Only when there's a finding of gross negligence or if an intentional tort exists will the court entertain the option of punitive damages. So big difference, big important level of exposure that increases when you have gross negligence. Let's talk about contributory negligence and comparative negligence. The first thing I want to say about contributory negligence is that this is not the theory that we have now. I really don't like the way our textbook talks about it. They really don't make the law in this area at all clear, in my opinion. So please disregard that section of the textbook and listen to what I'm going to say. Contributory negligence was the law in the United States, and as far as I know, in all common law jurisdiction for hundreds of years. The idea was this: a plaintiff can't sue successfully a defendant if the plaintiff contributed, even in a small way, to the accident happening. That was the rule in the United States into the 1970s, and there's actually places that it was the rule in the United States even into the 1990s. The big case in this area happened in California, and the name of the case is Lee versus Yellow Cab. You don't need to know that name, but that is the name of the case. In that case, Mrs. Lee was jaywalking. she shouldn't be jaywalking. That's a bad idea, but it's hardly a capital offense. It's hardly the worst thing anyone ever did. Probably most of us at some point in our life have jaywalked. It's not a good idea, but it's not the worst thing ever. Anyway, while she was jaywalking, she was hit by a yellow taxi. The yellow taxi was driving recklessly, was driving over the speed limit, and was committing several other traffic moving violations at the time. The yellow taxi driver was really acting irresponsibly, much more irresponsibly than Miss Lee was by jaywalking. Miss Lee was badly injured when she was hit by the yellow taxi. So she sues Yellow Taxi to recover her damages, all of their medical bills and assorted pain and suffering, things like that. Well, Yellow Taxi immediately filed a motion to dismiss the lawsuit, saying, look, Mrs. Lee was contributory negligent. She was negligent by jaywalking, and that's true. There's no two ways about that. She should not have been jaywalking. And the law of contributory negligence, which was absolutely the law in California in the early 1970s, says that if she even has a little bit responsibility for the action, she can't recover a dime from Yellow Taxi. And that's true. She under the law at that time, she would not be able to recover any money. And it wasn't until this case got to the California Supreme Court, the California Supreme Court said, we're going to overturn that precedent. It's a precedent that we've had forever, but we don't think that's good law anymore. We are going to say we don't want to continue having contributory negligence. We are going to replace contributory negligence with a new concept, comparative negligence, which we're about to talk about. Texas followed suit very, very quickly by a similar decision by the Texas Supreme Court, and the Texas legislature passed a law on this issue. So we were in the mid-70s, no longer in a contributory negligence environment. As a result, contributory negligence is not the law anymore. It is helpful to know the way things used to be so that you can understand more fully how things work now. But keep in mind, this is no longer the law, at least not in the United States. So let's look at comparative negligence. This is shared responsibility for the harm that results from negligence. What we're going to do is we're going to compare everybody's level of responsibility. We're going to look at all the plaintiffs and all the defendants. We're even going to look at other parties who aren't plaintiffs or defendants who maybe have some responsibility for the accident. And we're going to assign a percentage for each one of those individuals. Bob's 5% responsible. Louise is 37% responsible. Harry is 22% responsible. Dan is, whatever the percentage responsibility. Anyway, you're going to come up with numbers for everyone, the jury is, and all those numbers are going to add up to 100%. And so that is the way the system works. So let's just look at a couple of examples. So we're going to have plaintiff 1 and plaintiff 2 suing. So I'll have a first assign here. Defendant 1 and defendant 2. Okay, so the jury says plaintiff 1 is 10% responsible. And plaintiff 2 is 20% responsible. And defendant 1 is 30% responsible. And defendant 4 is 40% responsible. And let's say the damages that plaintiff 1 and 2 had in combination was $100,000. Well, this means that defendant 1 will have to pay 30% of those damages, or $30,000, and defendant 2 will have to pay 40% of that amount, of $40,000. So plaintiffs 1 and 2 will get a total of $70,000. 30 plus 40 is 70, $70,000. They are each responsible for 10 and 20%. They don't have to pay themselves that amount of money, but they aren't going to be able to get that amount of money from the two defendants. That's how comparative negligence works. There's a variety of ways, there's a variety of systems for comparative negligence. I'm going to explain to you how Texas comparative negligence works, but if you move to another state, you may see a different system. So let's just change up these percentages here. So I'm going to do another. I'm going to just have one plaintiff this time, and we'll have two defendants. So the jury in this case finds that defendant 1 is 20% responsible, and defendant 2 is 25% responsible. And he finds that the plaintiff is 55% responsible. In some jurisdictions, the fact that the plaintiff is over 50% responsible doesn't mean that he cannot successfully sue the two defendants. And of course, when plaintiff is filing the lawsuit, he doesn't know what the jury is going to hold, so he doesn't know whether the jury is going to find him 45% responsible or 55% responsible. In Texas, though, the rule is that if the defendant is more than 50% responsible, he can't collect any money from the two defendants. So in this case, instead of, let's say the damages were $10,000. Ordinarily, the defendant would be on the hook for 20% of $10,000 or $2,000, and defendant 2 would be on the hook for $2,500. But because the plaintiff is more than 50% responsible, then in this case, the defendant 1 has to pay $0, and defendant 2 has to pay $0. But if we were to lower this percentage to 50%, and we'll say make defendants here's 30%, then now suddenly defendant 1 is now responsible for $2,000, and defendant 2 is responsible for $3,000. So you can see how those numbers play out. Again, this information about how Texas work is not available to you in your textbook, because this is information specific to Texas, but you are still responsible for understanding it. Let's talk briefly about strict liability. This is when there's something inherently dangerous in a particular activity. Again, the wild lion that you keep in your reception area. Or maybe it's the bungee jumping business that you happen to be running. Things that you just really can't make any of these activities completely safe. And so when you run a business related to that, you're going to be responsible for the injuries that happen, even if you weren't negligent in how you're running the business, or even if you didn't commit an intentional act. You're going to be strictly liable, or liable automatically when harm follows. The textbook talked about how some states are saying, well, when you provide food to people and they become sick as a result of it, some states have been saying that's a strict liability situation. That doesn't seem to be a trend, though, that is picking up steam in Texas. I'm going to cover with you the oyster rule, and this is the statute that recovers this in Texas. This is a direct copy of the particular statute. Let me just read it to you, and we'll go through the specifics. In a product's liability action, a manufacturer or seller, of course this would be the restaurateur, shall not be liable if the product is inherently unsafe and the product is known to be unsafe by the ordinary consumer who consumes the product with the ordinary knowledge common in the community. So this sounds like, what does it sound like? The reasonable person standard, right? It's a very good definition of the reasonable person standard, that objective standard. And so we need to have this too. We need to know it's inherently unsafe, requirement 1, and it has to be known to be inherently unsafe, product characteristic 2, and number 3, the product is a common consumer product intended for personal consumption, such as oysters. Okay, we all know that bad oysters exist and sometimes are hard to tell. Tobacco and alcohol, they certainly can cause injury. But who of us knew that sugar was inherently unsafe and known to be unsafe by the ordinary consumer? I mean, I consider myself the ordinary consumer. I consume sugar, and I feel like I have ordinary knowledge common to the community, but I did not know sugar was dangerous. I might have thought possibility of butter being dangerous, but not really. I mean, if it's pasteurized and kept refrigerated, I don't think of it as dangerous. I don't usually consume castor oil, so I don't really have much of an opinion about that. But you can see there's some surprising aspects of this law. And we also have oyster. So the reality is that the restaurateur is not going to be on the hook if a person consumes oysters in his or her restaurant, because that item is inherently unsafe and is known to be unsafe. and that it is an oyster. So that's an example of where we haven't applied the strict liability theory, at least in the state of Texas, at least right now. Who knows what the future holds? So now we're going to talk about that third category of torts. We've talked about strict liability, we've talked about negligence, and now we're going to talk about intentional torts. So what is an intentional act? Well, it's a willful act. Our will, our decision-making part of our brain is involved in this, and it is undertaking a particular action. But when it undertakes the action, it doesn't necessarily mean that it intends the harm that's going to happen. So again, if I, for example, decide to cook, or let me put it this way, let's say I decide to, what would be an example of an intentional tort? I have an employee that I've dismissed, and I want my other employees to know why I dismissed the first employee, because I don't want them to engage in that same behavior. And I think if they know what this person did, and they know that person was fired for it, they would be less likely to do it because they don't want to lose their job. So I call my employees together and I say, hey, look, I just fired Bob because he was negligent in how he was driving the car. He was going significantly over the speed limit and he caused an accident, and I just can't put up with that. And so he's no longer employed here, and I just want to let you know that so that you will know not to engage in that behavior. Let's say Bob applies for some other jobs, and those particular employers contact me, and I tell the story about what happened. Well, it ends up that Bob really wasn't driving over the speed limit. And actually, if I had paid better attention to what the police officer said, I would know that, in fact, no, he wasn't driving over the speed limit. And so when I was saying that he was speeding, I was actually defaming him. Maybe I didn't intend to defame him, but I knew or should have known the truth, and I chose not to do due diligence to confirm that information. As a result, Bob has lost jobs that he otherwise would have gotten, and he would have been able to maybe retain his employment here, and his reputation has been damaged. People think less of him as a result of the things that I have said, so his reputation has been harmed in the community. I've committed an intentional act against him, even though I did not mean to cost him those jobs, and I did not mean to damage his reputation. It's not necessary that I, the defendant, intended the harm. It's only necessary that I intended the action that I actually took. So when we're looking at intentional actions of third parties, we're going to see, is it foreseeable? Is it reasonable for me to think to myself, wait a second, if I tell future employers that Bob was speeding while he was driving the company van, is it likely they're going to hire Bob? Boy, I don't think that's too likely. So it's foreseeable that my intentional action would have resulted in the harm that did result, Bob not being employable. Did I exercise reasonable care in how I completed that action? Well, did I actually ask the police officer what happened? Did I read the police report? Did I ask Bob what happened? Well, no, I didn't. Did I jump to a conclusion? And I didn't use reasonable care in how I confirmed the facts and communicated those facts to other people. So those are reasons why my intentional acts open me up to risk of successful lawsuits against me. Let's talk about the idea of negligence per se. Negligence per se is the idea that when a person violates a law or some other rule, and as a result of their violating that rule, they cause a harm, we say that they are negligent. It is inherently negligent, or negligence by itself. You don't need any other evidence other than the violation of the rule. That establishes for certain that the person was negligent. Now, it doesn't necessarily prove that the defendant violated the law. Excuse me, you have to prove the defendant violated, but it doesn't prove that the violation of the law caused the harm that the plaintiff had. So we still have to prove causation, but there's no longer any debate about breach of duty of care, where we can check that box off once we've established that the defendant violated a rule. That is all the evidence we need for negligence in terms of breach of duty of care. So we're going to end this lecture at this point, and we will have in our next lecture we'll go on to the next part of the presentation. As always, if you have questions about the topics that we cover, don't hesitate to send me an email message or come to my office hours, and we'll talk about those in more detail. Thank you for your attention. I hope you have a wonderful day.